Hello and welcome to today's webinar. My name is Robbie and I will be in the background answering any WebEx technical questions. We have a few housekeeping items before we get started. If you experience technical difficulties joining the WebEx session, please dial 1-866-779-3239 or you can message the WebEx producer using the Q&A panel. During the presentation, all participants will remain in a listen-only mode, and as a reminder, this event is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. We encourage you to submit written questions at any time during the presentation using the Q&A panel at the bottom right of your screen. Please type your questions into the text field and hit send, and please keep the drop-down as all panelists. I would now like to hand it over to your first speaker for today, Jim Livson. Jim, you now have the floor.
Good morning, and thank you for joining us this morning. Trey and I are going to present PTAB Top Stories 2020, Discretionary Denials, Motions to Amend, and Arthrex Oh My. Before we get started, I'd like to run through some instructions for the CLE and then materials after the presentation. Please note that all registrants for today's webinar will receive an email from MBHB within 24 to 48 hours containing a PDF copy of the PowerPoint and a link to an archived audio version of today's presentation. For those participants seeking CLE credit for today's presentation, please note there are two randomly placed PowerPoint slides inviting participants to complete a simple online poll question. You must complete both poll questions in order to confirm your active participation and thus be eligible to receive CLE credit. We encourage you to submit any questions you may have during the webinar presentation using the WebEx online question submission module. Time permitting, we will respond to the questions, and if time does not permit, we'll respond offline as the webinar concludes. Thank you. So I'd like to start with a roadmap of where we're headed today in the presentation. And we're going to cover four topics: discretionary denials, motions to amend. I'll be handling those, and Trey will be handling constitutionality and Arthrex and appealability. And so for discretionary denials, we'd like to review what are they and where are they headed. With Arthrex, that case was granted cert by the Supreme Court, and so Trey will be talking about where those petitions are and in the schedule for the Supreme Court and the implications of that case. Motions to amend, I'll review the benefits of those motions and the PTAB pilot program for motions to amend, which has been around for a year, and now we have a year's worth of data on the program. And then Trey will close it out with appealability. The Supreme Court had an appeals case this year, Thrive, and then the Federal Circuit followed that in Windy City and started to distinguish it a little bit. And so Trey will revisit appealability. So first, we'd like to start talking about discretionary denials. And in some sense, every denial of institution is discretionary because it's with the board. It's their decision whether to have a PTAB trial or not. I'm focused on what have been called non-merit denials of institution. These are different than the standards that the board applies. Reasonable likelihood that one of the claims is unpatentable is the IPR standard, and more likely than not, one of the claims is unpatentable is the PGR standard. But it's important that these other discretionary denials we get a look at those because they're increasing this year. There's been new board case law on them. There's actually ongoing APA litigation about some of these denials and potential PTO rulemaking in this space. So the two discretionary denials I'd like to focus on, these are the procedural ones I mentioned, are based in the statute, and practitioners refer to them as 314 denials and 325D denials. And so 314A, that's the statute where the director institutes, and the statute says may. And so the Supreme Court has in SAS said that 314A invests the director with discretion on the question whether to institute. And we'll see the board has case law developed on what it means to have a 314 denial. But in short, it's looking at whether the PTAB proceeding is going to be duplicative of a proceeding that is out in front, that's already started. Then the 325D denials relate to whether the same or substantially the same prior art or arguments have already been presented before the office. So this is a mechanism for the board to look at whether the content of the proceeding is going to be duplicative of what the office has already seen, whether it's in examination, re-examination, a previous PTAB proceeding. And the context of these 314 and 325 denials are shown by institution rates, whether the board is starting PTAB trials. And currently the rate is 65% from the life of PTAB proceedings. The high was the first year they started, 87% of proceedings were being instituted. And this year, through this year, it's a low point, 56%. And these discretionary denials, these 314 and 325 denials are increasing. And there's certainly something to keep in mind as a petitioner and patent owner. So let's talk about the mechanics of the 314 and 325 denials before we move on to where they're headed. So the 314 denials, the board's principal cases on this are General Plastic and NHK Spring. These are precedential decisions from the board. And then the board also discusses 314 denials in the trial practice guide. But it's looking at events in other proceedings. And the board is going to make an assessment of whether it would be an inefficient use of board resources to have a PTAB proceeding. And the board has put out some non-exclusive factors in the FinTIV case. That case came out this year, also a precedential decision from the board. And it really is getting at how far along is this other proceeding. And the board wants to make sure that they're not going to have a trailer PTAB proceeding that's going to be duplicative of another proceeding that's already started. And so proximity of the trial date is important compared to when the deadline for a final written decision by the board, whether the petitioner and the defendant are the same party, the overlap of issues. So all these factors get at the extent of the duplication of the PTAB proceeding. And again, we said 325 denials are about whether the content of the proceeding is going to be duplicative. And the board this year in Advanced Biosonics, another precedential decision said 325D denials are looked at in a two-part framework. Let's make the assessment whether it's the same or substantially the same art or arguments. And if so, the petitioner has the burden to demonstrate the office erred in a material way, that the examiner made an error. And it's worth the board's time to revisit prior art that the office has already considered. Now, 325D denials have their own multi-factor test, 6 factors as well, non-exclusive. These are the Beckin-Dickinson factors, another precedential case from the board. But they're similar to the FinTIV factors in that, again, they're just getting at whether this is going to be duplicative, whether this is going to be the board just rehashing what's already happened. So, you're going to be looking at the prior art that's asserted in the petition, the prior art that was involved in examination, and a cumulative analysis of that art. The extent the art was evaluated in examination, that factor looks at whether it was actually used to reject the claims. Certainly, if it wasn't used at all, that really weighs against a 325D denial, but the board has said even if the reference was cited in an IDS and considered by the examiner, that is not a strong reason to say, we can't have a PTAB proceeding. It's really when the examiner has used the reference to reject the claims. And then the other factors get at overlap, how well the petitioners pointed out the examiner's error. And this last bullet is the extent that additional evidence would change the outcome, more evidence since the earlier office proceeding. Now, before we move on to where are these discretionary denials headed and some of the ongoing litigation and rulemaking, I just wanted to stop and check in on patent owner and petitioner strategies for 314 and 325 denials. So these issues need to be taken up in the petition and the preliminary response. This is going to take up space in the petition and the preliminary response. There's a word count that practitioners have to deal with. But if the petitioner doesn't think ahead and preempt these types of arguments, the patent owner is going to have a clear shot at arguing them in a preliminary response. Essentially, a motion to dismiss type of argument, or board, this is a waste of your time. And if the petitioner wants to wait and see how the patent owner frames it, there's a chance they might not get to reply. Replies to preliminary responses are not as of right. And, you know, with the board having so much case law out there on this, I think the board would be skeptical of a petitioner getting a reply just to argue 314 and 325 if there's been no development in the case law. Those types of replies, I think, are usually for merits type arguments. And certainly if the patent owner doesn't raise 314 and 325 in their preliminary response, that they're forever going to hold their peace, because these are not arguments for the trial phase of a PTAB proceeding. And you probably want to argue both in the same proceeding. NHK Spring, the case that I mentioned earlier, the board denied institution under both 314A and 325D. So specific strategies for 314 denials really look at, for the petitioner, when to file their petition. Under the statute, a petitioner has 1 year when they've been served with an infringement complaint to file their petition. But if we look at the definitive factors, if you wait that full year or a day before the 1 year bar, if you're in a district court with a fast schedule, a rocket docket, that's going to hurt the petitioner. So there's pressure on the petitioner to file early, but that's going to maybe impact the content of the petition, and the petitioner has to be concerned about estoppel, that this is their best shot, and if they hold back in the petition, they may be barred from raising other arguments down the road. On the flip side, the patent owner wants to file suit in a district court with a fast schedule and put pressure on the petitioner and perhaps insulate themselves from a PTAB proceeding if they can get into a court with a fast enough schedule. And so the Western District of Texas, there's been a lot of discussion about that court and the court schedule, and there's been a lot of fights about trying to maneuver if you're a defendant out of the Western District of Texas. And so we'll see where all that plays out. Certainly reminiscent of similar arguments about the Eastern District of Texas, but at that time, 314 and 325 weren't as robust in the Eastern District of Texas practice. Specific strategies for 325D. Again, this is the content of the arguments and the art, and so I think it's important for practitioners to frame the prior art and reasons for allowance in the petition. Petitioner can get out in front and put a technical spin on why the claims were allowed in examination or confirmed in a reexamination, and then they can say, board, I'm bringing new art that fills that gap. The office said the art didn't teach this, but now I found art that does. On the flip side, the patent owner is going to want make cumulative arguments and come up with a technical spin about why everything that the petitioner is showing is cumulative, and really get into the art that was used in examination and have a theme of cumulativeness. And one other important thing to think about for patent owners is, do you have an open family? Do you have related continuation applications? If you do, I've been involved in a case where the petition was cited very quickly, and art that was cited in the petition in a continuation application. And the examiner in that con had reasons for allowance that said, well, this combination, this is hindsight. And the examiner was really denying institution of the petition himself. And the patent owner was able to use that reasons of allowance as evidence in their preliminary response as a data point to show the board, look how cumulative this is. And for the patent owner, even if it's a close call on 325D, I think that type of assessment is elastic with the merits. So the board might look at the merits in a certain way if the 325 issues are very close, or vice versa. All right, I'd like to now move on to where are denials headed and with ongoing litigation and rulemaking. There's an APA action that I mentioned. It was filed in August of this year in the Northern District of California. The plaintiffs are large tech companies that see a lot of patent infringement cases. Apple, Cisco, Google, Intel, and Edwards Life Sciences is also part of that group. They're arguing that the case law that we went over, which they dubbed the NHK FinTIB rule, is unlawful, that it conflicts with this one-year time bar we discussed, that it's trying to force petitioners to file before the one-year mark, and that's contrary to congressional policy. The rule is arbitrary and capricious because you have this vague set of factors that don't produce consistent outcomes. And they also raise a procedural argument that these are substantive rules that were not adopted through notice and comment rulemaking, and they're invalid for that reason. Interestingly, a group of interveners have tried to get into this action, and if the plaintiffs are big tech companies that are defendants, the interveners are eight groups, but they can be seen as a collection of smaller patent owners that are typically plaintiffs in infringement cases. And they've asked to intervene, and so U.S. Inventor is one of these parties. And then they've also filed a motion for temporary restraining order and preliminary injunction against the PTO. The interveners want the Northern District of California to compel the PTO to promulgate a rule on 314A denials. And just to step back here, this is just a 314A denial case. The 325D argument about cumulativeness and is the content of the proceeding duplicative, that's not at issue in this case. Now, the intervener's motion for TRO and PI is fully briefed, and the hearing is set for mid-January. And the Patent Office and Apple both oppose it, and they say that this relief is extraordinary, that the court is going to force the agency to do rulemaking. But the main complaint is in its early stages. The PTO hasn't even responded yet to Apple's complaint, attacking the case law, the board case law behind 314A. So we'll see where this case goes. An offshoot of this is Cisco filed for mandamus at the Federal Circuit about 314A denials and made the same arguments that they're making in the Apple APA challenge. The FinTIB factors are unlawful, arbitrary and capricious, no notice and comment rulemaking. And so the Federal Circuit, rejected this idea that you could appeal the denial of institution. And there's been a lot of litigation about that, and Trey's going to talk about that later. But this was an institution decision and it's not appealable. But on mandamus, and that's really where the fight was could Cisco get an order from the Federal Circuit to the board to have a PTAB proceeding, because the standard for mandamus is a clear and indisputable right. And the Federal Circuit said Cisco did not establish that it's not clear that the board made a gross error of law relying on parallel proceedings in its discretion to whether to institute or not. And the Federal Circuit also noted that Cisco can raise these, they're making these arguments in the APA challenge, and they can raise validity in a district court case even if they don't want to. Now, the rulemaking that I mentioned, at this stage, it's a request for comments. The day after the PTO filed its opposition in the intervener's motion in the Apple APA case, they put out a request for comments. So the comment period closes tomorrow, and there have been around 250 public comments so far, mostly from individuals and some small industry groups. So I'd say they'd all be aligned with the intervener. The big tech companies, such as plaintiffs, have not submitted comments. And what's interesting here is this a strategy by the PTO to short-circuit or delay the Apple case? Plaintiffs are arguing about notice and comment rulemaking. Well, the PTO is starting that process. The interveners want to ask the district court to force the PTO to do rulemaking. Does this moot that request? Now, the interveners did file a paper in support of their motion after this request for comments came out, and the interveners in the Apple case said that this is not even a half measure because this is not formal rulemaking, and the interveners noted many requests for comment die on the vine without publication. Now, commentators have said that if the board were to issue a regulation on discretionary denials, that would be helpful to synthesize all of their case law, because practitioners have to chase down several different cases now to get a full picture of the board's rules in this space. And rulemaking on this point would cement the board's authority over institution. So the specifics of this comment, if there's a day left to comment on it, the board is asking about proceedings in other tribunals. That's squarely in this 314A regime, and parallel proceedings that we talked about. And that's the second bullet here. And the board asks whether they should continue their case-specific analysis that they've already done in the case law. Should they just disregard parallel proceedings entirely from institution, and that's just not a factor that should be considered? Or should they go the other way and deny every petition if there's ever a parallel proceeding? The other topic that's received less attention is this idea of serial petitions. The board polices that. So if you file another petition on the same patent, there's a multi-factor test the board will look at as well, whether they should deny institution. And so they're asking for comment on that. And again, they're in the same three worlds. Case-specific analysis that they already do in their board decisions, disregard the idea of serial petitions entirely, or that's dispositive. If there's any prior petition on the same patent, you can't have another one. And I think it'll be interesting to see how the Apple case and the proposed rulemaking play out in a Biden administration. It could very well die on the vine, as the interveners suggest, with a transition from an administration. And we have some precedent here when we went from the Bush administration to the Obama administration. You recall that under Director Dudas, the Patent Office had promulgated rules about how many continuations an applicant can file. And that led to APA challenges that went up to the Federal Circuit. And when the Obama administration took over and Director Kapos took over at the PTO, the Patent Office no longer defended that regulation and did not move ahead with it. And so there is some precedent that there may be a transition in how the office looks at some procedures. And the last note is, could Congress get involved here? They could. in June of this year, 15 entities sent a 10-page letter to the House and Senate Judiciary Committees arguing about 314 denials and why they're dangerous. These included groups like the Electronic Frontier Foundation, the National Retail Federation, the High Tech Alliance. So it is possible Congress could amend 314A or 325D and give more guidance. I would say that Congress probably has higher priorities than discretionary denials and PTAB proceedings, and certainly Congress is more divided. It will be more divided than it has been in the last Congress. So that may also weigh against them taking action in this space. With that, I'd like to turn it over to Trey, but now it's our time for our first poll question. So if you are seeking CLE, please enter the phrase PTAB in the panel and then click submit. So enter PTAB in the poll and then click submit. So the poll will stay up for a few minutes, but we will move on here, and Trey will talk about Arthrex.
All right, thanks, Jim. Yeah, and we'll hop right into Arthrex. We'll give this poll question another 30 seconds or so to allow everybody to make sure that they get their first poll question in for CLE credit before hopping into what, depending on how much of a Supreme Court constitutional issue nerd you are, is probably the most exciting case that we've seen since oil states involving constitutional issues and patent issues, and a position that many find themselves in, not really knowing what the landscape looks like moving forward in terms of what, if any, Arthrex's impact has on patent cases this year and next year. So with that, we'll hop right into the actual slides on Arthrex. And so we want to talk about very briefly what Arthrex means, and then more importantly, what's going on with Arthrex now and what that means to everybody's patent practice currently. So as a brief review in terms of what Arthrex means, getting it down to sort of the one sentence, Arthrex was a case that came out authored by Judge Moore about a year ago in late October 2019 that held there's an appointments clause defect in the statutes that govern the constitutionality of APJs that are impaneled for panels at the PTAB. And so because there is this constitutional defect in terms of the appointments clause, final written decisions issued by those judges, those APJs that were not constitutionally appointed, are therefore invalid. And so what has been done about it by the original panel and sort of since? Well, the panel in Arthrex said, well, there is this constitutional defect, but we could fix this pretty simply by sending these final written decisions back to the PTAB and having a panel of constitutionally appointed APJs to sort of rehash these arguments and issue a new final written decision. Pretty simple, right? Well, not really, because the way the Federal Circuit and the PTAB and frankly patent practitioners have sort of navigated this over the past year has been anything but concrete. So let's talk about a couple of different examples that Arthrex, in ways Arthrex has been applied, and some things that we might have learned along the way. So there certainly exists a set of Federal Circuit decisions post-Arthrex that are very deferential to the holding in Arthrex and have held that the proper course indisputably for appeals concerning final written decisions before the Federal Circuit post-Arthrex is to be, again, very deferential to the Arthrex decision and just send those back for review by a constitutionally appointed panel. And sometimes that happens even without oral argument. One example here, and it's a case that we'll talk about a little bit more in depth later, is this image processing technologies v. Samsung Electronics. This is a case in which briefing had been completed and oral argument was on the calendar. And again, this was in a pre-COVID world, but the Federal Circuit ultimately canceled oral argument in that case and said, you know, let's just kind of forget about this merits briefing that the parties have spent a lot of time and effort on, and because we're going to be deferential to Arthrex, we're going to send that back based on the Arthrex vacate and remand by itself. But this has not been consistently how other panels have dealt with it. So, for example, other panels have said, Arthrex relief, parties aren't entitled to Arthrex relief if it wasn't raised in your opening brief. That is, there are several instances in which a party could have raised an Arthrex challenge, and we'll talk more about that later. But certainly it could have been raised before the PTAB in the original proceeding, like it was in Arthrex, or it could have been raised in the notice of appeal, or at minimum it could have been raised in the opening merits brief. And in, for example, Custom Media Technologies, it wasn't raised in the opening brief, so the Arthrex challenge in that case was deemed forfeited by the Fed Circuit panel that looked at it. But, there have been at least other panels and other judges that have commented on this. For example, the Sanofi case that's cited directly hereafter. This is, again, is a dissent from Judge Newman, but Judge Newman says, quote, it is well established that when law changes and the case is on appeal, the change law applies. And parties, whether they had it in their opening brief, whether they had it, somewhere along the way, they are entitled to the same foundation of a nation ruled by the law that the same law that's applied to parties in that pending litigation should have the benefit of the change in law. So some differences there between different panels. Other panels have kind of come somewhere in the middle and at least at a minimum asked for additional briefing on the issue post-Arthrex. If you have an Arthrex challenge, maybe it was part of your notice of appeal, maybe it was part of your opening brief, maybe it wasn't, but the panel is going to be interested in more than the bare invocation of the phrase Arthrex to get you the relief that you're seeking. And there is this sort of other realm of possibilities and potential problems which really are remedy-based. What is the proper remedy for curing an Arthrex defect? Do we really have to send it back to a panel of constitutionally appointed judges? Can we just look at the merits, we being the Federal Circuit, just look at the merits of the case and deal with it ourselves? So those remedy questions are kind of all over the map, too. So where does that leave us? That leaves us with kind of looking at where we are now, which is, again, a pretty mixed landscape of application and analysis from the Fed Circuit and other parties. And the Supremes are going to take this up, have currently taken up the writs, and we'll talk some about that, to be heard over the next few months and ultimately, hopefully, decided by summer of next year. So, again, we are about a year out from the original panel decision from Judge Moore. Earlier this year, in March, the Fed Circuit denied rehearing en banc, so the controversy is squarely within the purview now of the Supreme Court. But because the issue wasn't taken up en banc and the panel decision really sort of governs and controls what's going on with Arthrex from a lot of people's views, including the PTABs, the PTAB proactively, around the same time this year, early April, late March, basically took the entire group of what we'll call Arthrex-affected proceedings. Those are proceedings that came after the panel decision, but before the window for appealability had closed, and said, we're going to stay these. Even though these have been granted for vacate and remand, GVR'd, by the Federal Circuit, we're not going to get ahead of ourselves and worry about a whole new constitutionally paneled panel of APJs to review these final written decisions before we get some clear indication from the Supreme Court on this issue, whether to take it up or not as a threshold question, but then ultimately as a merits question, what they're going to do about it. So in terms of how these challenges have been presented, and they're all, and by challenges I mean the writs of certiorari now in light of the denial of en banc for the Federal Circuit, they're really kind of all over the map, because you can imagine there's a lot of parties and a lot of decisions that have been affected this, including the Arthrex principal parties, but a lot of other parties as well. And moving forward, there are really going to be sort of four groups of parties that are going to be driving the conversation for what happens next. And those four groups, I think, are important to sort of delineate and think about how, again, they're going to impact one another and the conversation moving forward. So the first group, the first in line, was the first Arthrex petition. This came from Arthrex, and it really involved two questions for certiorari. One, seen here, is sort of a Fifth Amendment's takings question, whether the retroactive application of an IPR to patents that were applied for before the AIA violates the Fifth Amendment. Do we have a takings issue potentially? And then two, it's sort of a waiver Court of Appeals powers change in law question, which is whether a Court of Appeals can invoke the forfeiture principles to refuse to address a constitutional claim in a pending appeal despite an intervening change of law. Well, although these two questions may be, pretty interesting, certainly from a scholarly standpoint and a practical standpoint too, this writ of cert was denied in October of this year. So this sort of first in line lead petition from Arthrex alone is sort of a non-starter. So the second group, which also involves Arthrex, this group is more accurately sort of described as the Arthrex principal parties. These are the parties that were involved in the Arthrex specific dispute, and that is Arthrex, Smith as the principal parties, and then the U.S. government, the USPTO, as an intervener. And around the same time, although these are three separate writs, they were consolidated, and two of the issues that were presented in the litany of issues between the three writs were taken up by the Supreme Court. So cert has been granted for these two issues, and they're the two issues displayed here. These are the specific questions that the Supreme Court took up. But, to kind of sum up what the two issues are, the first issue has been, the issue that, frankly, most of the ink has been spilled on in this sort of conversation, which is, are APJs actually principal officers that have to be appointed by the president with the Senate's advice and consent, which is, again, hearkening back to the panel decision, what Judge Moore and the Fed Circuit held is that APJs are constitutionally appointed principal officers, and because they weren't constitutionally appointed, that's really the defect that underlies this entire controversy. But if not, those APJs might be considered inferior officers whose appointment Congress has clearly delegated to the department head of the specific agency in question, here the USPTO director. And so if those APJs are actually inferior officers, not principal officers, there is no constitutional defect because their appointment by the USPTO director was constitutionally significant. So the threshold issue there is the first question. And the second question, which we only get to if potentially they are principal officers, they being the APJs, is whether this decision in Arthrex from the Federal Circuit, that is whether the administrative patent judges, the Fed Circuit has properly cured that appointments clause defect in the current statutory scheme by severing the application of the relevant statute to those judges. So, do we have a problem in terms of principal versus inferior officers? And if so, has that problem been cured by the Arthrex decision itself in severing the application of the statute? So those are the two questions, again, that have been granted for cert. And interestingly, although it was a question presented in more than one brief, is the waiver question. This sort of when, if any, does waiver kick in terms of where you presented and or potentially preserved this issue, whether it be before the PTAB, whether it be in the notice of appeal, whether it be in the opening brief, or somewhere else before the Fed Circuit. And so the waiver question, again, is whether an Arthrex challenger really needed to raise that appointments issue at some specific point along the way, and if not, are you sort of getting off on a bit of a technicality in terms of not being deferential to changing law, and you didn't properly preserve it. But again, although it's presented in this sort of principal parties group of litigants in the Arthrex panel decision, the Supreme Court didn't take it up, or hasn't taken it up currently. So for now, the Federal Circuit's holding that there's no waiver at this point stands for these parties moving forward. Now, quickly, we'll touch on the schedule. Coming up pretty quickly, opening briefs for these consolidated appeals are due a week from today. If there are going to be any amicus interveners or sort of amicus commentators, those are going to be due pretty shortly thereafter. And then you can sort of see the briefing schedule, which should resolve itself as far as principal briefs go in late February, which leaves, although it hasn't been, set in stone, it leaves the oral argument date to probably be somewhere in late Q1, early Q2, and hopefully a decision by summer of 2021. So one interesting point in terms of the oral argument itself is that so far the Supreme Court has said we've got 1 hour in terms of presenting the Arthrex challenges. It's going to be split, presumably evenly, between the three parties, that is Smith, Arthrex, and the U.S. government. And again, we'll probably see that oral argument happen, hopefully, pretty early next year. So those are the two groups and sort of where we are on those groups. The third group, which is a really interesting group, is the set of parties that are directly affected by the decision in Arthrex. That is, the parties that were in the window of appealability in terms of final written decisions and got their notices of appeal on file with the Federal Circuit because of Arthrex. And what are all those parties doing? Well, those parties, which involve currently around 75 proceedings, those parties, their petitions have kind of fallen into two camps. One, individual petitions. So, if you are the petitioner who didn't like, the IPR petitioner who didn't like an Arthrex GVR by the Fed Circuit, those individual parties certainly can file their writs, and many, many have. But in the midst of all of that, very interestingly, the government filed what many have called an Omnibus Petition. And this is where image processing v. Samsung comes back into play, because it was the lead case in terms of the Omnibus Petition. And by Omnibus Petition, I mean that the government filed its own writ for cert, naming all of those IPR parties and final written decisions that were affected by this. So whether you wanted to be in the fight or not, the government kind of pulled everybody who could potentially be in this current universe of affected proceedings in via their Omnibus Petition. Now, this case has since been recaptioned to the USA versus Luma, because the parties in image processing v. Samsung have settled and pulled out of this Arthrex dispute. So they can't be part of the case caption itself, much less the main case caption. This was actually distributed, or the notice for being distributed for conference before the Supreme Court in this Omnibus Petition, serendipitously, was issued yesterday by the Supreme Court and has set a conference for distribution on this petition for December 4th. So we'll know pretty quickly if the Supreme Court's going to take this one up and fall sort of in line with the principal Arthrex parties, or if these issues in the government's Omnibus Petition are not as interesting and may be denied like the original Arthrex petition. Importantly, the waiver question is squarely within the government's Omnibus Petition in this specific writ. This is the caption 20-74. And so, the Supreme Court could deny it outright. It could take up or reiterate that it is taking up this APJ inferior officer question, which is also part of the government's petition, this Omnibus Petition, or it may take up the waiver question for the first time in terms of granting cert. And this is a specific question. This is whether the Court of Appeals erred by adjudicating appointments clause challenges brought by litigants that had not presented such a challenge to the agency. So this is the sort of the more aggressive waiver point, which is, the government's really saying, did you have to present some at least colorable argument in terms of a waiver challenge before the original agency, that is, in your actual IPR proceeding? Okay. And so with that, this is just sort of a summary slide of the questions that, have been taken up. Yeah, sorry?
No, I just wanted to jump in and wanted to get your take on the Supreme Court's grant of cert in two Social Security Administration cases, one from the 8th Circuit and one from the 10th Circuit. So they granted cert this month after the Arthrex grant, but those involve this appointments issue and whether you needed to raise a challenge, in the agency there, the SSA, and both of those circuits said you needed to. It was an exhaustion of remedies point. So do you think we can read any tea leaves from that, did the Federal Circuit get it right, and that's why the court didn't grant cert on waiver in Arthrex, but is going to look at waiver in these two SSA cases?
Yeah, I guess that's a good question. The practical answer is we're going to know likely in the next month or so after this waiver question is represented now by the government via cert petition to the Supreme Court whether they're interested in the question or not. Now, certainly if they don't take that question up in this petition, then the tea leaves seem to indicate that they're not interested in it and they think the Fed Circuit got it right. As a more, sort of comprehensive point, I do think it is interesting, and it's something, you and I and me and a lot of the colleagues have talked about through the years, is there are a lot of direct parallels in terms of agency makeup between the Social Security Agency and the USPTO. There was a lot of analysis that came in that sort of comparison, even back in oil states and other sort of constitutional challenges that are raised. Because those Social Security decisions are fairly contemporaneous this time around in terms of waiver, maybe they are more important. So, good question, Jim, and we'll see sort of what happens from here. So very quickly on this last slide about Arthrex, the principal question, did the Fed Circuit get it right? Is it fixed now via Arthrex, or is the universe of cases that could potentially be affected, is it a bigger universe? Is it limited to sort of these 75 active proceedings potentially? What about waiver? We talked about retroactivity. Is it, a current problem, a retroactive problem, a proactive problem? We'll know. Is this Congress's job? The Biden administration may affect that calculus as well. We'll see how newly appointed Justice Coney Barrett falls in line in terms of, her views on these patent rights. And we'll see sort of if, like I said, when and if the Biden administration affects this analysis at all. But we'll keep you abreast of what's going on in this case, which, we're right in the middle of. And hopefully we'll get some resolution for pretty soon. And with that, we are back to our poll question, our very clever poll question term, PTAB. We'll leave this up for about 60 seconds. Go ahead and put that in like Jim said, and be sure to hit submit to ensure that you get the CLE credit. And with that, I'll pass it back to Jim to talk about motions to amend.
Thank you, Trey. So this next segment is where we are on motions to amend, benefits of them, and this pilot program that's now been around for a while, so we have some experience with it. And I think motions to amend are important because they have been held out as a benefit to the patent owner, that this is different than district court litigation because you may be able to, your patent may be able to survive if you amend the claims. As we've seen, since motions to amend have been around with PTAB proceedings for several years now, commentators have called this benefit illusory because the board has granted very few of the motions. There's been case law developments this year about how motions to amend and substitute claims are handled, and we have data on the pilot program, and the PTO has released more data on motions to amend in general, and so I think it's good to check in on all those points. And so I'd like to first just talk about nuts and bolts of a motion to amend. You present substitute claims in the trial phase, and it's a whole set of other papers in addition to the papers against the original claims. So usually the motion to amend is filed at around the time of the patent owner response, but the board can set it so it could come in a little earlier. Usually you're going to have expert testimony with your motion to amend. The requirements for the motion are set out in this regulation that I have on the slide. Your amendment needs to be narrowing. It has to be responsive to something at issue in the IPR, and you can't enlarge the scope. You can't introduce new matter. The regulation says there's a presumption that you only get one substitute claim per each challenged claim. So I've been involved in cases where we just have one substitute claim, but you could have a handful based on the amount of claims that were challenged in the petition. And what the patent owner needs to do is they need to walk through the priority document and show support for these new features. Now, once those substitute claims are put in the case, then this year we've had a comment that it's full-blown examination, and that is from Judge O'Malley's dissenting opinion in Uniloc this July, and she was not happy about where Uniloc went. The idea is that the petitioner has the burden of persuasion to show the substitute claims are unpatentable, and so the petitioner has to come up with arguments in their opposition. But where that has gone is that the petitioner is not limited to what they've argued in the petition, and they're not limited to the art that they presented in the petition. And the Uniloc case in particular was about, it was an IPR, and so IPRs are limited to 102 and 103 on documents, and the petitioner wanted to oppose the substitute claim on 101. And the board said that was fine, and the Federal Circuit panel that took this up split on it 2-1 and said it was okay as well, with Judge O'Malley dissenting. And the point of disagreement was the statute that sets up IPRs, does the limitation on 102 and 103 grounds on documents apply to substitute claims? And the majority said no. There are different phases of the proceeding. And the majority looked to reexamination where you have a similar limitation, but in case law, the Federal Circuit has said you can look at priority. You can look at 112 issues in reexamination, and so that the court drew an analogy. So any ground is open to challenge the substitute claims, and that's where Judge O'Malley stated this is full-blown examination, and that's really contrary to what the board is, right? The board is an adjudicative body. They're not examiners, right? The patent has already been through an examination. So there's a tension here about how you deal with substitute claims that is still playing out in the case law. So now we're in a situation of what happens when the petitioner doesn't oppose the substitute claim. The petitioner might not feel there's a need to do that. They might think they're fine with the amended claim. There's no infringement threat from the amended claim. And so this year the board has dealt with how do they proceed in that situation. Do they just let the substitute claim go through if it's unopposed because this is an adjudicative proceeding? So that the Federal Circuit this summer in Nike said that the board may raise new issues for substitute claims, even if they're not raised by the petitioner. Now that case was limited to prior art of record. The point, though, that the Federal Circuit made is the patent owner has to have an opportunity to respond. And so what happened in Nike was the board relied on a reference in the record for the first time in the final written decision as teaching a limitation that neither party ever discussed in the IPR. And so what the court said was if the board is going to go off on its own and raise a patentability issue for a substitute claim, they have to inform the the parties that the board's intending to rely on a reference for a teaching in a disputed limitation and request supplemental briefing. That would be one example of proper APA notice. Another example would be if there is going to be an oral hearing, as many trials do have, the board can let the parties know that they should be prepared to discuss a reference in connection with a substitute claim. And that was another example of proper notice. So following the Nike case, the board itself had a decision in Hunt and Titan, it was later this summer, about when they would raise a new ground. So the Federal Circuit said the board may, and the board said it should only do this in rare circumstances. And this was a precedential opinion panel decision authored by the chief administrative patent judge, and it was on rehearing. So in Hunting, the petitioner challenged the original claims for anticipation over a reference, but challenged the amended claims, the substitute claims, as obvious over that reference. And then in the final written decision, the board said, well, no, the substitute claims are anticipated by that reference. And so anticipation was just not raised in the proceeding with respect to the substitute claims. So what the precedential opinion panel said is that in the rare circumstances where a petitioner ceases to participate in the proceeding or there's record evidence that's readily identifiable and persuasive, the board should not raise new grounds itself. But if you get into those situations, the board has a duty, there's a public policy to stop bad patents. And so the board looked to that policy. Again, the Hunt and Titan noted that the board has to give the patent owner an opportunity to respond if the board is going to use a new ground. So what's left here is to what extent can the board look for new art? The Nike court left that open because that issue was not in the record, and so the court explicitly said we'll leave that for another day. And, looking at where we are, I think the board would have authority to raise new art. And as long as they give the patent owner an opportunity to respond, I don't see an issue with it in the structure of the case law and the statutes. Now, that being said, I think the board would rarely do that. Hunt and Titan says you've got to have readily identifiable evidence. And so how would the board get that? Now, a patent owner has a duty to put in an IDS, with their motion to amend. They have a duty of disclosure. And so perhaps the board could look at art coming in an IDS, even if the petitioner hadn't pointed to it. But again, that's probably not going to be readily identifiable. So the pilot program I'd like to touch on has been around since spring of 2019, so we have data from about a year and a half now. And it's this idea that the patent owner can get preliminary guidance from the board, non-binding guidance, and then decide to file a revised motion. And if the patent owner files the motion, the petitioner files its opposition, then the board gives preliminary guidance. Does it comply with the regulation? Very short paper or a call with the board. If the patent owner decides to file a revised motion, that moves the hearing back a month, and there's a new round of briefing on the revised motion. And so I'd like to talk about the board's statistics this year. And the board, the Patent Office has noted that motions to amend are down around 60% from the last reported 3 quarters. And even though petitions are down and institutions are down, they're not down as much as this number. So there's something else going on with why motions to amend are down. And maybe it could be that there's this idea of the illusory benefit of motions to amend, or maybe you're in a situation where they're just not practical given a parallel infringement case. The pilot program has been receptive. most people are using the program, and a lot of people are filing revised motions. So this program seems to be helpful in terms of transparency. But again, the PTO statistics show that motions to amend are still a rare occurrence. Only about 10% of PTAB proceedings have had a motion to amend, and in that set, only about 14% of them have been granted. So I'd like to close this segment with patent owner and petitioner strategies. And there's quite a bit, because this is a whole satellite process that the patent owner can put into the IPR. And if they are going to go down this road, they have to make sure that it's not going to harm their remedies or infringement liability in the district court case. Is there going to be intervening rights? So they have to check that box. But after that, they have to make a decision whether they want the amendment to be contingent or non-contingent. And that is, most amendments the board won't pick up until after they decide the original claims are going to be canceled. But a patent owner might say, no, I'm not going to defend the original claims or some of them, and I'm just going to move on with an amended claim. If the patent owner does that, there could certainly be consequences about perhaps an adverse judgment, perhaps estoppel as to the original claims. The other decision the patent owner has to make is how much are they going to argue patentability in the motion. They're only required really to do a 112 analysis. But does the patent owner want to preempt 102 and 103? And if the patent owner does that, do they just do the art that was cited in the petition and explain why the amendment is better than the art on patentability reasons? Or do they want to argue other references that they've put in their IDS? Do they have an IDS? So that's a strategy call. And then the final issue I have for the patent owners here is whether they participate in the program. I think more information the better. At the same time, though, there's very quick turnarounds if you participate in the pilot program, and maybe a patent owner would feel that's too quick a turnaround. The petitioner's strategy is are they going to oppose an amended claim? Is it in their interest to do so? And if they do, what's the strength of the opposition? Now, the problem is there going to be estoppel if they don't? Hunt and Titan suggested there would be. That question wasn't really before them. But it seems to make sense that there would be, if you could raise or reasonably raise a challenge to a substitute claim, your time to do it is before it gets put into the patent. So that's what the petitioner faces. And I think one thing to think about here, to stay tuned, is the impact of district court judgments on original claims and what that does to a substitute claim. So I think there's still a lot of litigation left on motions to amend, and we'll continue to see if they do become a benefit for the patent owner. And with that, I'd like to hand it to Trey to close us out with appealability.
Thanks, Jim. Yeah, so the last topic we're going to cover today is going to be appealability, particularly in light of two decisions that came out very recently, Thrive and Windy City, and what issues can be appealed. To set the stage for these two issues, and kind of going back to something that Jim touched on earlier, is, once you get your institution decision from the USPTO, for better or worse, what can you do about it? And what you can do about it is governed by 35 U.S.C. 314D, which pretty simply says no appeal, that any determination by the director whether to institute on an IPR is, quote, final and non-appealable. So a pretty tough burden to carry in terms of, people that are not satisfied with the decision on whether to institute or not, which is certainly different from the final written decision that you may ultimately get in an IPR, which you can take an appeal of as a matter of right. So where do we sit on how this is actually applied? There's a lot of cases and a lot of commentary and a lot of things through the years since the institution of these proceedings. But the most important case, and the one to really set the stage for today and generally, is from the Supreme Court again, which came in Quozo, where although Quozo was really a clean construction standards case, Justice Breyer went a bit out of his way to talk about institution decisions under 314D and the appealability of those institution decisions. And really, at bottom, the decision on whether those are going to be appealable, those institution decisions are going to be appealable under 314D, turns on the question of what issues you're appealing and whether those issues fall into one of two camps. And the two camps are, one, sort of things right in the wheelhouse of the director and sort of the more ordinary parts of an IPR proceeding, and two, what Justice Breyer and others since have talked about, things that are sort of outside of that sort of normal IPR purview, which have colloquially been called shenanigans that may be taken by the USPTO in an IPR. So what's an example of something that may fall in line with these shenanigans of sorts, something that would be appealable as part of an institution decision under 314D? Well, one example was, as you see here, this quote, constitutional questions that depend on other less closely related statutes and really get in line with, due process or more constitutional rights. So those would be sort of considered more in line with shenanigans and potentially appealable issues. But what have we really seen since then? Well, one that we've seen since then, time and time again, has been whether there's a time bar that is an issue in terms of the filing of the petition, the IPR petition, that is, sort of in line with a statute of limitations. And this comes from the statutory language itself. That is, parties have a year that parties of the real party in interest are privy to the petitioner, have a year from the time that the complaint is served in the district court proceeding to file their petition for IPR. And that would seem like a fairly straightforward question. Are you within that year? Are you not in that year? And if you're not, and the USPTO gets that wrong, that's certainly a threshold issue, a clear legal error potentially, that should be appealable and serve as a basis for invalidating any analysis that's undertaken in a subsequently instituted IPR proceeding. So looking at sort of the lineage of how this issue's been treated, 5 years ago in a case, the Fed Circuit said that the court can't review the PTAB's determination that the petition's time barred. That was ultimately reversed in a subsequent case in 2018, Wi-Fi 1, in which the Fed Circuit took this up en banc and flipped the case and said, although we have this clear indication from Congress that these powers are delegated to the USPTO director in sort of the ordinary course of an IPR, this is such a fundamental question and legal error that these should be able to be appealed and or ultimately reversed by a court of appeals. So Wi-Fi 1 overruled a case. Well, this year, the Supreme Court steps in once again. This is a 2020 case authored by Justice Ginsburg and goes back to the reasoning in a case and ultimately the reasoning presented in Quozo, which is sort of the interesting part and why we want to keep reiterating Quozo, because it seems to be sort of the guidebook for how the Supreme Court is going to treat these issues that either fall within the ordinary course of IPR proceedings or something more dramatic like these shenanigans. And in this case, Justice Ginsburg, again writing for the court, held that a challenge to a petition's timeliness under 315B is really just an ordinary dispute, quote, ordinary dispute of an institution-related statute. So as the case in Quozo, 314D overcomes this strong presumption through the American judicial system for appealability of these issues. The problem is that in between Quozo and Thrive, we have SAS, which you'll recall is a decision about partial institution and whether that was a 314D threshold issue. And Justice Gorsuch, in that opinion, writing for the court, said that it was a fundamental question and then those shenanigans could be invoked in terms of the USPTO's handling of those issues. and it was an appealable issue. So, I think a lot of commentators have come out and said that the court really got this one wrong in Thrive. I don't know if it's right or wrong, but I do know that it is very difficult to potentially square with Justice Gorsuch's writing in SAS. And so if you take SAS to be sort of the gospel truth in terms of, how to apply quozo and fundamental questions and shenanigans, it is difficult, again, to square this time bar, sort of statute of limitations-esque issue, which presents a fairly clear legal error that should be fairly easy to evaluate by the USPTO with SAS. And what's more, in Justice Gorsuch's dissent in Thrive really follows that line of thought. That is, in sort of a Scalia-esque manner, and it's worth reading certainly in its entirety, but that this whole point about admitting legal error, which in this case the USPTO did, admit that there was error in terms of the one-year statutory prescription. This entire exercise is a property taking by bureaucracy, which is, of course, forbidden by law. And, quote, it leaves the core judicial powers to agency officials and leaves the disposition of these private rights and liberties to bureaucratic mercy. The Fed Circuit, since Thrive, has looked at this issue and its impact in terms of joinder and sort of split the baby of sorts and said that whether a joinder applicant's petition for IPR should be instituted under 314 is not reviewable, but whether to join the party as a joinder applicant is reviewable. So it kind of falls more in line with the 314 analysis and not being deferential to appealability, but more deferential to the USPTO director's powers. Other issues that frequently come up that sometimes catch people by surprise, settlement is not a reason to remove the proceedings, the IPR proceedings. Of course, the USPTO and PTAB can go on with an IPR proceeding even if the parties settle. It's permissive to dismiss, not as of right. And then, of course, we all remember the sovereign and tribal immunity cases from a couple of years ago that, sovereign and tribal immunity is not going to get you out of these either. So with that, and in closing, because we're coming up on the end of our time together this morning, which we certainly appreciate, and thank you for hanging out with us to talk about PTAB. I'll give you a shameless plug. Jim and I both work together in the PTAB Trials Practice Group here at MBHB. We represent parties on both sides of the V, and we've had some real success based on our technical prowess and deep technical bench, particularly over some other firms that don't have such a technical roster, both in terms of our outperformance of those firms on institution rates, post-institution settlement rates, which, by the way, are up in the past year and a half, and unpatentability and final written decisions. So just, like I said, a quick plug to let you know if there's ever anything we can do to help, we'd love to help you. Our contact information's here. Be sure to connect with us on social media. And with that, I say thank you again. Have a great week, and I hope everybody's staying safe.
Thank you. Bye.